Welcome back to Good Law, Bad Law. My guest this week is Steve Vladeck. He's a law professor at the University of Texas, and we're talking about a fascinating case that was recently decided by the Supreme Court. Now, you might think that a case involving allegations against the Arab Bank, one of the largest banks in the Mideast, which has a huge financial presence in this country, in a case alleging that the bank facilitated acts of terrorism by groups like Hamas, that's just the kind of case that should be heard in federal court in this country. But wait till you hear the discussion about how the Supreme Court walks us through legal history dating back all the way to 1789 and the original statute that Congress passed creating the federal court system, and watch and listen how this court spins out and reaches a very surprising and important result. I know you'll find this a fascinating episode. Enjoy. My guest today on Good Law, Bad Law is law professor Stephen Vladeck. Stephen, thanks very, very much for being on the program today.
Thanks for having me.
We are going to talk today and for the next little while about a really important Supreme Court case that hasn't been getting near enough attention, I think, for how fascinating the background is and the implications this could have, which is when can a corporation be brought into court in the United States for an act of terrorism that occurs overseas, and the court reaching a very important decision that I think is going to have some broad implications, at least the way these kinds of cases have gone in the past. But before we get into that, Steve, I wondered if you could just give us a little bit of background on yourself.
Sure. So I teach at the University of Texas School of Law. I've been teaching for about 13 years now. I focus my work on the intersection of the federal courts and national security law, access to justice, human rights law, et cetera. So that's part of why these cases about the Alien Tort Statute are, such an important part of what I try to focus on, what I try to teach, what I try to write about.
And also, I mean, you do have some media experience too. I note you do some on-air analysis for CNN, talking about issues involving the Supreme Court, and you also co-host a podcast.
Yep. So I help CNN both on air and actually mostly behind the scenes with their coverage of the Supreme Court. And then my colleague Bobby Jesner and I host a podcast, basically roughly a weekly podcast called the National Security Law Podcast about, shockingly, national security law.
Right. And of course, I've become a big fan of podcasts since I got into this myself. So I appreciate that you have that background, and I checked out your podcast and it looks fascinating, and I hope people will check that out too. Well, let's talk about this case, which is called Jesner versus the Arab Bank. And I want to get a little bit of background on the case and then sort of work through some of the history that the Supreme Court goes through in its analysis and explaining how it reaches its decision in the case. Give us a little background on the case itself and what brought this matter ultimately to the Supreme Court.
Sure. I mean, so the case is actually a consolidated series of 5 lawsuits that were filed against the Arab Bank in federal district court in Brooklyn between 2004 and 2010 by a pretty large class of plaintiffs. I mean, well over 6,000 plaintiffs. And the basic allegation uniting these 5 lawsuits is that the Arab Bank was directly and indirectly responsible for financing and for helping to facilitate a series of terrorist attacks in the Middle East over a 10-year period that produced and resulted in the deaths and serious injuries of many of the plaintiffs and or their families. So it's basically a claim by victims of these terrorist acts overseas, attacks carried out by Hamas, by other terrorist groups, that Arab Bank was liable for basically violating international law insofar as it facilitated the financing of these attacks.
And the Arab Bank, I mean, this isn't some small bank on a street front in Brooklyn. I mean, this is a major financial institution, as I understand it, a Jordanian bank, and one of the largest Arab banks in the entire Middle East, right? This is a major
That's
problem.
right, and that's right. So the Arab Bank, unlike some other Middle Eastern countries that actually have national banks, the Arab Bank is technically a private entity,
Mhm.
but it's a major, as you said, Jordanian financial institution. It has branches all over the world, including in New York, and according to the Jordanian government, it accounts for somewhere between 20% and 33% of the total market capitalization of the Amman Stock Exchange. So this is not a small potatoes organization. I think that's part of why this was the defendant who these plaintiffs went after. When you
Mhm.
have these kinds of terrorist acts overseas, the folks with deep pockets who are potentially going to be liable most often are going to be the banks.
Well, and I mean, deep pockets for sure, but also, I mean, in a terrorist attack, it might be pretty difficult to identify an individual who you could actually bring into any court in the world. I mean, some of these terrorist attacks involve suicide bombers
Yep.
and the like. So how maybe impossible even to identify who an individual is who could be responsible. And here you
And,
have
and, and even if you could, they're almost certainly not going to have deep pockets.
they're not going to have any ability to compensate. And these are victims, like you said, thousands of them, including some Americans, right?
Yes, including some Americans, although, we should distinguish between claims under the Anti-Terrorism Act, which was not at issue in the Supreme Court decision, and claims under the Alien Tort Statute, which requires the plaintiffs to be foreigners. So there actually are other claims in this case that will still go forward insofar as they're brought by American citizens under a different statute. What the Supreme Court was considering in its decision was the claims by foreign nationals under the 1789 statute, the Alien Tort Statute.
Okay, so let's bookmark the Anti-Terrorism Act. We'll come back to that when we look ahead at where this whole issue goes from here. But so let's focus then, as you say, on the statute from the Alien Tort Statute, and you said it was the Alien Tort Statute of 1789. We don't often get to talk about a law that goes all the way back to the time of the Constitution. So, what is the Alien Tort Statute, and how did these thousands of victims of Hamas terror look to that law as a way to try to get into a U.S. federal court?
Sure. So the Alien Tort Statute, which Judge Henry Friendly once referred to as a legal Lohengrin, is this fascinating old piece of the original Judiciary Act of 1789, the statute that basically created the federal court system. And what it says today is that the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. There's some debate about what its original provenance was. Its modern salience, its modern relevance, is it was basically dragged out of the cobwebs by human rights organizations in the 1970s and 1980s as a way of pursuing damages suits in U.S. courts for massive human rights violations by whether Americans or foreigners, where the plaintiffs were non-citizens and where the defendants were sufficiently present in the United States such that there could be personal jurisdiction over them. So the landmark case here was a 1980 Second Circuit decision called Filartiga versus Peña-Urala, where the Second Circuit basically reinvigorated the Alien Tort Statute and said, you can use this statute if you are a non-citizen to enforce fundamental norms of international human rights law, in that case, the norm against torture, to recover damages for human rights violations by defendants who are subject to U.S. jurisdiction.
And again, just to round out the factual basis here, nobody's alleging that the Arab Bank itself is an institution, and it becomes critical to how the court parses this out, that it's an institution, not individuals, not an individual or multiple individuals who are being sued here. But nobody's saying that this bank actively and directly engaged in torture or terrorism attacks, but that they, even through their presence as part of the American banking system broadly, facilitated and made possible these groups to carry out these acts, right?
That's right. And indeed, that these acts wouldn't have been possible but for the efforts of Arab Bank to basically circumvent a series of domestic and international banking regulations and legal restrictions that would otherwise have made it impossible for Hamas and other terrorist organizations to finance these terrorist attacks.
Well, so let's go back a little bit to, you alluded to this, the original understanding of the Alien Tort statute from 1789, that it has an original application, it had an original understanding. I want to just give that a brief mention because one of the issues that Justice Kennedy takes on in the majority opinion for the Supreme Court, and that Justice Gorsuch, the newest Supreme Court justice, really emphasizes in his concurring opinion, is this issue of the role of the courts versus the executive branch and the legislative branch. Is really about the relationship between our three branches to make these kinds of decisions ultimately. But way back in 1789, there was a really good reason for creating, albeit a limited way in which these types of international disputes would get heard in a U.S. court, right? So that, I mean, can you tell us a little bit about that? Because that's a fascinating part of the history, I think.
I mean, yeah, I think I should be clear. I mean, I think there's some debate over the history. I mean, I think Justice Gorsuch tells a particular version of the historical debate over why the statute was enacted. You know, history, of course, is just an argument without end. But there are reasons to think that part of why the Alien Tort Statute was enacted was to deal with the particular problems that could arise from incidents against foreigners that were specifically focused toward the U.S., right? The context in which foreigners might have claims against, defendants either in the U.S. or who were U.S. persons for which there was no other obvious mechanism, for which there was no other obvious. Now, part of the problem is that is a very narrow reading of the statute, and it's one that the courts have largely, disagreed with. Not that was what Congress was originally thinking about in 1789, but that the text of the statute, because after all, we're supposed to be textualists, doesn't limit it to those contexts. That the text of the statute is pretty capacious and simply requires that the claim be by an alien for a tort in violation of the law of nations. So, we have this contrast on the one hand between what I think everyone agrees was a pretty modest intent of the enacting Congress with what really is very broad text that the federal courts have, for the most part, consistently over the last 35 years, interpreted pretty capaciously to allow for any suit that falls within what the text seems to permit.
Well, and this is every constitutional issue that comes before the court. How broadly do you interpret? How narrowly do you limit the language based on the text that we have all these many years later? Justice Kennedy tells a bit of the history in giving the background to the statutes in question. He tells of in 1784. This is actually a story that comes out of Philadelphia, where I'm based. Tells the story of how the French minister in 1784 lodged a protest with the Continental Congress after what's described as a French adventurer, the Chevalier de Longchamp, assaulted the secretary of the French legation in Philadelphia. And this was part of what gave Congress the idea to create an opportunity for these types of disputes to be heard in a court in this country.
No, listen, I think that's right. I mean, I think there's no question as to what the provocations were for the statute. Where I think things get more controversial is that Congress responded to those provocations by enacting a statute that was broader than just what those provocations suggested, right? That is to say, that rather than just passing a statute that would have clearly applied to those circumstances, where a foreigner is, wounded in tort by another foreigner on U.S. soil, Congress passed a statute that creates two predicates: that the plaintiff be a non-citizen and that the claim be for a tort in violation of the law of nations. And so, I think there's a completely understandable debate over how capaciously to read that language. It wouldn't be the first time that Congress, in responding to a provocation, legislated more broadly. And I think, so I think we should be careful about equating what gave rise to the Alien Tort Statute with how we should understand its scope.
Well, and of course, when Congress passes a statute, as they did here, and leaves us all these decades later with broad language that is subject to great interpretation, then that's what the court's got to do. And since the statute uses the phrase "law of nations," what does that mean? And how is
Yeah,
that,
and
and how's that come down and been interpreted over time?
well, and I think it's worth stressing. I mean, Congress has had multiple opportunities to amend the Alien Tort Statute over the years, and it's never done so. I mean, the only time it came close was in 1991 when it enacted a companion statute, the Torture Victims Protection Act. And in the process, it resisted efforts, even in the face of, by then, 11 years of pretty powerful circuit precedent, recognizing the ability to use the Alien Tort Statute to sue for human rights violations. Congress did not touch it. So, I think we'll get there. I mean, I think the majority opinion in this case, Jesner, is predicated on a separation of powers understanding that I think is a bit woolen, because if we're actually talking about the separation of powers dynamic here, Congress consciously left the Alien Tort Statute intact, even as the federal courts were interpreting the law of nations more and more capaciously.
So, in other words, and you gave us a bit of this background in the 70s and 80s, as human rights advocates discover this statute and see it as a basis to bring those accused of human rights violations into an American court. You're saying Congress certainly was aware of this and could have, if Congress had decided to, looked to narrow the statute, mend it and narrow it, rather than leaving it as a vehicle that some could use to try to get these cases heard here.
That's right. And I mean, we should be very careful to, not overread into Congress's failure to act. I just think that it complicates the very, I think, one-sided separation of powers story that Justice Kennedy tries to tell in the majority opinion, because, I mean, frankly, we can all agree that it's up to Congress in the first instance to provide remedies in this space. But I think the plaintiffs in these cases would argue Congress did back in 1789, as the courts have consistently interpreted it. And so it's actually, I think the plaintiffs would say it's actually inappropriate for the courts through simply, through judge-made interpretations to scale back the plain text of the statute.
Take us then to the point where, as you were describing earlier, the courts start to expand or allow some of these cases to actually be heard. And of course, to get a case heard in a federal court, you have to have jurisdiction in that court. The court has to say, yes, this is a case that is properly here, as opposed to a court finding there is no jurisdiction and really kicking it out on that basis before even getting to a beginning discussion about the merits of the case. So how do courts starting in the 1980s even start to find jurisdiction, a basis for hearing these types of disputes?
Well, actually, I don't think the problem was jurisdiction, because the Alien Tort Statute is itself a jurisdictional statute.
I see.
I think the larger problem was, what was the substantive law, right? Why was this jurisdictional statute consistent with Article 3? So, just to sort of be a Fed courts nerd for a second, Congress, in order to confer jurisdiction upon the federal courts, has to be providing jurisdiction over one of the 9 groups of cases that are outlined in Article 3, Section 2 of the Constitution. And so one of the arguments that folks have made against the Alien Tort Statute is that if it just allowed an alien, a non-citizen, to sue another non-citizen for a tort claim that did not itself arise under federal law, that would be unconstitutional, because there's no basis for federal courts as a constitutional matter to hear such cases.
Okay.
The Supreme Court responded to that in its first decision interpreting the Alien Tort Statute, the first of 3, its 2004 ruling in a case called Sosa versus Alvarez-Machain. And what the court says in Sosa is the Alien Tort Statute does not allow suits for every single tort in violation of the law of nations, but it does allow suits for torts in violation of what the court called peremptory, non-derogable, well-established norms of international human rights law, which, in English is basically those fundamental human rights rules that no country can depart from, basically the creme de la creme of international human rights norms. So we're not necessarily talking about controversial ones like environmental degradation, but torture, genocide, crimes against humanity, conduct that is never lawful, even when a domestic government purports to authorize it. And so SOSA says those cases can go forward because in those circumstances, these customary international law norms, the norm against torture, the norm against genocide, are basically tantamount to federal common law. And so they're federal law, and these cases satisfy the federal question requirement of Article 3.
Sorry, just to make sure that gets explained for non-civil procedure lawyers, non-civil procedure law students out there, when you say federal common law, so this would be something working its way through the law, but not necessarily an actual statute passed by Congress.
That's right. And, we do have some examples of contexts where Congress passes a statute, but doesn't actually pass a jurisdictional statute, doesn't actually provide substantive law to govern the dispute, but everyone agrees that the federal courts are supposed to apply judge-made federal rules as opposed to state law rules. And so, the most common example of this is when two states sue each other in the Supreme Court of the United States. Almost all of those cases don't involve federal statutory law, right? Congress does not generally legislate interstate water rights, for example. But everyone agrees that it would be silly if in a dispute between North Carolina and South Carolina, the Supreme Court applied North Carolina or South Carolina law. Right? And so folks understand that the provision of jurisdiction in that circumstance is an invitation to the Supreme Court to fashion federal rules as it deems appropriate. So SOSA basically takes that logic and applies it to the Alien Tort Statute and says in cases where the plaintiff is a non-citizen alleging some kind of violation of a peremptory norm of international human rights law, the federal courts have the power to enforce that norm because of the Alien Tort Statute.
So I don't know if this is a dumb or a smart question, but if we're using phrases like the law of nations, I mean, and if we say that, as SOSA did, and the SOSA court said, there are certain sort of undeniable examples of the law of nations that would qualify to be heard in a federal court in this country, things like, as you said, torture, genocide. There are institutions of international law. There are international agreements, the Geneva Convention and things like that. Is the SOSA court saying it's in effect adopting those and making those part of the federal judge-made common law?
So, I think the Alien Tort Statute actually separately allows for the enforcement of treaties. And so when it comes to the Geneva Conventions, I don't think you have to worry about the common law side of it because the Geneva Conventions is a treaty to which the U.S. is a party. I think that the larger issue is there are both some human rights treaties to which the U.S. is not a party. One example is the Convention on the Rights of the Child, where I think we are one of the only non-parties, along with North Korea and Somalia, where you would still have the argument that there is such prevailing international consensus about these rules that they can be enforced in civil litigation under the Alien Tort Statute. So, I think the whole point of SOSA is if it's really messy whether there is such an international law norm, then that's not going to be enforceable under the Alien Tort Statute. It's for those cases where no one disputes that international law recognizes this norm, that the Alien Tort Statute is going to be available and indeed still going to be a viable tool. And I think that's the important contrast, because SOSA seems to actually endorse in pretty broad strokes at least the core of the modern progressive reading of the Alien Tort Statute, only to have the Supreme Court in two subsequent decisions, first Kiobel and now Jesner, tear pretty big chunks out of that holding.
Right. So Kiobel is the second of the three cases that you alluded to earlier. So let's just get a brief summary on Kiobel, and that helps us understand what Jesner did recently.
Kiobel actually initially presented the question that the court ultimately takes up in Jesner. So Kiobel was a post-SOSA alien tort suit against Dutch Petroleum, basically, right? The Shell gas company. And in Kiobel, the Supreme Court initially granted cert on the question of whether corporations can be proper defendants to a suit under the Alien Tort Statute, because if the Alien Tort Statute is a creature of international human rights law, international human rights law actually is not super positive about corporate liability versus individual liability. Corporate liability is much more a creature of U.S. domestic law. Well, after the case was initially argued to the Supreme Court, the court actually set it for re-argument on a different question, which is whether the Alien Tort Statute applies, quote, extraterritorially, unquote, that is to say, to conduct that takes place outside the territorial United States. And what the court ends up deciding in Kiobel is that, in general, the answer to that question is no, that for a tort to be actionable under the Alien Tort Statute, the tort has to, quote, touch and concern, unquote, U.S. territory. So right off the bat, that takes a pretty big chunk out of SOSA, because it seems to remove from the field of play most human rights violations if they were committed overseas, as opposed to human rights violations where there's at least some connection to the United States.
Well, and that I think is going to bring us right to Jesner, because in Jesner again, they're trying to get at that problem, avoid that issue by naming the Arab Bank, which has a huge presence in New York here in this country. But before we get there, I have to ask about 9/11 and how does that fit into this? Because there you clearly have aliens involved in an act of terrorism, the plane bombings in effect here in this country. So there, you'd have to say that the conduct clearly involves and touches our soil and this country. So how does the 9/11 experience fit in with this whole line of cases?
So, I don't think it fits in very well, because the problem is that first, the actual perpetrators of 9/11 are all dead, and second, right, insofar as there might be sort of residual perpetrators, they're not here, and so, right, it's not clear, how you would be able to establish personal jurisdiction over them. We've seen this, for example, in efforts by the victims' families to hold the government of Saudi Arabia and other entities liable even for indirectly supporting the 9/11 attacks, where a number of those lawsuits have been thrown out for the basic reason that the non-sovereign defendants are generally not subject to jurisdiction in the U.S. because they have no physical presence here.
Okay.
The other thing is, again, the Alien Tort Statute is for non-citizen plaintiffs. Of course, most of the victims of 9/11 were citizens. And so there actually is still pending litigation under the other statute we talked about, the Anti-Terrorism Act, arising out of the 9/11 attacks. The Alien Tort Statute is really more for circumstances in which you've got non-citizen victims. And usually what that means is, of necessity, we're going to be talking about, misconduct that is typically overseas. That's why Kiobel is such a big deal, because by, paring back the extraterritorial scope of the Alien Tort Statute, there aren't that many, mass human rights violations that have their locus on U.S. soil, right, for better or for worse. And indeed, there was a circuit split after Kiobel where you had, for example, the 11th Circuit, the Federal Appeals Court in Atlanta, holding that you could not bring an Alien Tort Statute claim against the Chiquita Banana Company for human rights violations overseas, even where the claim was that the decisions that led to the violations were made in their U.S. headquarters. Contrast that with, for example, the Fourth Circuit's decision in the Abu Ghraib case, where that court said, even though torture at Abu Ghraib was on foreign soil, it was torture committed by U.S. military contractors on a U.S. military base over which the U.S. had exclusive jurisdiction, so that could go forward under Kiobel. So Kiobel created this big headache over just how much of a nexus plaintiffs had to show between the underlying human rights violation and U.S. soil. One of the interesting things about the Jesner case is the Trump administration, in an amicus brief, basically urged the Supreme Court not to decide the corporate liability question, but to send the case back to the Second Circuit to get rid of it on extraterritoriality grounds.
Meaning that there wasn't a close enough connection to
exactly
in this country. That is
exactly
curious. I mean, when we get to some of the rationales Justice Kennedy offers in the decision in Jesner, I'll have a question about that because Trump obviously campaigned on and is leading on a very pro-business agenda. So it's interesting that Trump didn't want to, or the Trump administration through the Justice Department didn't want the court to reach the very question that the court actually did reach, which is, whether a corporation can be held responsible under this law for these types of crimes or these types of wrongs, I guess.
Yep.
So that's what the court ultimately then does decide it's going to address, which is the distinction between an individual and a corporation, and what those differences mean in terms of how this law is applied. So since the plaintiffs, these thousands of victims, looked to try to have this case survive by choosing a defendant, the Arab Bank, which had, they thought, enough ties to this country to avoid the Kiobel issue. But they ultimately have the case thrown out because the court rules on the question of whether a corporation can be found responsible under this law. So tell us how the court gets there.
Well, so I mean, there's an irony here, which is that the court actually ended up deciding even a different question from the one on which it ostensibly granted cert. So the court granted certiorari on the question of whether corporations, period, could be liable under the Alien Tort Statute. A question that, of course, would implicate U.S. corporations to exactly the same extent as foreign corporations.
Right.
And what's, I think, most interesting about Jesner is that that's not the question the court decided.
Mm-hmm.
In a case that was briefed and argued solely about the the general question of corporate liability, the court's actual decision rests on a much more specific holding about foreign corporate liability, and actually leaves open the possibility of domestic corporate liability. So, I think it's worth stressing that even on the terms on which the Supreme Court itself thought it was taking this case, it decided something else, which, I don't think is necessarily to redeem it, right? Narrower is not always better. It's just different.
Mm-hmm. Well, and that's the question that I was kind of bookmarking and wanting to come back to, and here we are, because the Supreme Court does give a nod to the idea that there are many instances where a corporation is treated like an individual under our law, under U.S. law. I mean, you can think of First Amendment cases that the court has taken on, finding that even in the Citizens United case, campaign finance, where corporations are treated as individuals, or enough like individuals, but distinguishes that body of law from the way corporations ought to be treated here, and specifically talks about this idea that if we're going to bring corporations into cases in this country, as Justice Kennedy says, this would imply that other nations, also applying the law of nations, could hail our corporations into their courts for alleged violation of the law of nations.
Right.
And that seems to be a pretty powerful rationale for not finding corporations could be held responsible in our courts.
Well, or it's a pretty powerful rationale to believe that our corporations shouldn't be engaging in human rights violations on other countries' soil. I mean,
well, you would hope not, but how some other country interprets what is a human rights violation, we might have no control over that.
But so I guess, take a case like the Abu Ghraib case, right? So in the Abu Ghraib case, you have a U.S. military contractor, where if you take the allegations in the complaint as true, which, at least at the motion to dismiss stage, we should do, the allegation is that you have a U.S. military contractor engaging in torture on a U.S. military base in Iraq. And so I guess, my response is, if you really believe that a corporation in general should not be liable for human rights violations because we're worried about reciprocity, I worry that you're going to sanction, all kinds of misconduct by U.S. or foreign corporations in those circumstances. I think that's part of what pushed Justice Kennedy toward a ruling that was more about foreign corporations, mm-hmm. right? That if it was, it wouldn't look so bad if we were actually continuing to hold U.S. corporations liable, but not foreign corporations, on the theory that Jordan will hold the Arab bank liable for us if they really did violate this use Kogan's norm of international law, this peremptory norm. And I guess I have two responses to that. The first is, do we really have faith that Jordan is going to hold the centerpiece of its financial institution liable even for, a violation of what we all think is a peremptory norm of international human rights law? And second, even if we do, where in the text of the Alien Tort Statute is there any indication that we should differentiate between not just classes of defendants, but classes of defendants based upon whether they are, U.S.-based or not, right? That is to say, it's a perfectly rational decision, I think, for a legislature to make. But insofar as this is the Supreme Court, interpreting an unchanged 1789 statute, I just, I have some real concerns about the court, writing into the statute these distinctions that make, plausible policy sense, but that certainly don't appear on the text.
Well, and I guess the way they get around that or explain that, rationalize that, is by making this a political question, a decision saying Congress can legislate specifically and expressly allow for cases to proceed against corporations, but looking at history and looking at other prominent examples where this has come up, first of all, Congress has not done so, and even looking at other examples from international law situations, that's not the way things have proceeded. And Kennedy gives the example from the Nuremberg trials.
Right, but again, that would make sense if the rule the court enacted was about corporate liability writ large. Of course, it's not, right? So the two problems there are, first, Kennedy's defense of a rule about foreign corporate liability is actually a defense of a rule about corporate liability, period, which is not the rule he adopts. And second, again, I think if we're going to have a serious conversation about Congress here, this is not a circumstance where Congress has done nothing. This is a circumstance where Congress passed this statute that includes no such distinction. And then at various points in history where it had a chance to either, clarify or scale back the statute, chose not to. And so I just, I worry about a situation where the court says, even though Congress has in fact acted in this space, we're not sure they really meant it. And so we're going to read it this way just in case they actually didn't mean it. But that's not usually how we do.
Well, right, but he's holding himself out as actually following what he says was intended by this. So I guess it really it depends on where, from your vantage point, whether you think you're being true to the text and true to the intent, or whether you're reading something.
But again, I think it's telling, though, that the strongest policy arguments Justice Kennedy offers for why we ought not to allow these kinds of defendants to be sued is not limited to the actual line he draws. Right? And I think that's a pretty powerful indictment of the line he draws, right? Which is, the only thing that really separates a domestic corporation from a foreign corporation in this context are the foreign policy ramifications of allowing these cases to go forward. That's quite different from the question of corporate liability writ large, which is where the Nuremberg precedent comes in. So, I guess what I'm trying to say is I think Jesner would actually have been more convincing analytically if Justice Kennedy went further and said the real problem here is in fact corporate liability, by making it a rule about foreign corporate liability that really, I think, leaves the impression that, he basically made up his mind about how he wanted the case to come out and then looked for whatever arguments he could find that might support it.
Right. So it really boils down to the court saying, we just don't want these cases heard in American courts.
But not all these cases. Again, right? I think Justice Kennedy, it's quite clear that there was not a majority, even though a couple of the concurrences lean in this direction, right? It's quite clear that there was not a majority to foreclose all corporate liability under the Alien Tort Statute. And so, I think the key is that what they're worried about, what Kennedy's worried about at least, is the foreign corporate defendant. Interestingly, what Justice Gorsuch is worried about is all foreign defendants, whether or not they're corporations. And so, I think you see a real split among the justices as to what the real problematic feature of this case is.
So where do you see, Steve, where do you see this going from here? Because we certainly, there are other human rights claims that people are going to bring. There are other, clear acts that would fall within the subject matter of this statute that could lead to controversies and disputes that could be brought in this country in our federal courts. Where do you see this going, given the trend line with this most recent decision?
And I think the trend line is general skepticism of these kinds of civil suits in general. I think we're going to see some alien tort statute cases continue to go forward. I mean, the Abu Ghraib case is still going forward in the federal district court in Alexandria, Virginia, because there you have a U.S. corporate defendant and you have at least a claim that it's sufficiently close to the U.S. So, the alien tort statute is still going to be there for U.S. corporate defendants and maybe for foreign individual defendants, although those tend not to be especially good defendants.
Right.
I think the far more robust area of litigation is going to be under the statute we discussed at the beginning, the Anti-Terrorism Act.
Right.
At least when we're talking about acts of international terrorism as opposed to other kinds of human rights violations. And there, I mean, the interesting point is, Congress, right before President Obama left office, actually dramatically expanded the scope of liability under the Anti-Terrorism Act in a statute called JASTA, the Justice Against Sponsors of Terrorism Act, which is just now making its way into litigation as to just how far that goes. So, I think the short version is the federal courts are going to have an easier job when the underlying claim is about international terrorism in providing relief to victims, and a much harder job when it's some other mass, categorical human rights violation. And whether that's a distinction, that we actually think is appropriate is, I think, a messy question.
And the distinction too, that the Anti-Terrorism Act would require the victim to be a U.S. citizen. Is that right?
A U.S. national, so a citizen or someone with like some kind of long-term permanent immigration status.
Okay, gotcha.
And so certainly non-citizen plaintiffs are going to have a much harder time, getting into U.S. courts with these kinds of cases. When you have large-scale human rights violations, I mean, the reality is you can often find both U.S. and non-U.S. victims to be plaintiffs. But I think the reality is that it's going to sort of tilt the scales in these cases toward litigation over acts of terrorism and away from litigation over acts of torture, extrajudicial killing, genocide, crimes against humanity. And again, I think it's not obvious to me if we were designing a system from scratch that those are the choices we would make.
Fascinating. Steve, thank you so much. This has been an incredible conversation about, the case, I think, as I said, hasn't gotten a lot of attention, but it should, and we'll post a link to the court's opinion if anyone wants to read it. Some of the history itself is worth the read, and then with Steve helping guide us through the trend line of these important cases to bring us up to the present, I think people have a good way to try to follow along and understand the significance. So for that, I'm grateful. And again, Steve, thank you so much for being on the program.
No, thanks to you. It's my pleasure.
It was great. Thanks again.
Yep. Talk to you soon.